And before I make an announcement to the audience, I just want to see counsel at the sidebar for one moment, please. While waiting for the jurors to assemble, I just have a short statement to make to the press and to the audience, reminding the press that you may never photograph jurors at any point during the trial. Electronic recording and transmission of any bench or sidebar conference is also prohibited to be videoed or audioed. Any conferences between counsel and client, any conference between the court and the clerk, and the court and court officers also may not be video or audio recorded. Witnesses under the age of 18 may not be photographed or video or audio recorded. The pool cameras may only record or photograph during the proceedings. Therefore, you cannot record or photograph during a recess. You may begin after the jurors enter the courtroom while Court Officer Gator does the morning greeting, and you must stop when the jurors rise to leave the courtroom. If you're not operating one of the two authorized pool stationary mechanically silent video cameras or one of the pool silent still cameras, you cannot use your cell phone, camera, or other electronic device to take any photographs or video anything, even if you are a member of the media. If you are operating one of the three specifically authorized cameras, that is the only camera that you may use. Any person who is not a registered member of the news media is not allowed to use cell phone, cameras, or other electronic devices in the courtroom. Any attorney who may have a cell phone, tablet, or any other electronic device must have it turned off, not just silenced, and put away. A reminder to the media and the attorneys to check now to make sure that your cell phones are in silent mode. And a reminder to all observers, media, and counsel, please do not talk in the courtroom. This trial will elicit emotion and sympathy. I do not expect people, especially those involved with family in this case, to remain stoic and behave with equanimity throughout this trial. That is unrealistic and more than can be expected of people. Should any person observing this trial reach a point, however, where understandable emotions might interfere with the jury's fact-finding function, I would ask you to please temporarily step outside the courtroom to protect the jury's role as the sole and exclusive judges of the facts in this case. Are they all here? Nope. Okay. All right. We're going to just wait a couple of minutes for the jurors to line up then. They're not quite ready. Court will be in recess.
All right.
The last juror, we should be ready to start in just a couple of minutes. Court will be in a short
Court will be
recess.
in a brief recess. Justice of the Superior Court, now sitting in Salem, within and for this county of Essex, draw near. With your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. You may be seated.
Good morning, ladies and gentlemen of the jury. I have a series of questions for all of you. If you can answer any of my questions is yes, please raise your hand. Otherwise, there's no need to respond verbally to any of my questions. Any of the jurors have any difficulty following the instructions of the court not to discuss the case among yourselves or with anybody else? Any of the jurors have any difficulty following the instructions of the court not to do any independent investigation concerning this case and avoid any information from any source other than in the courtroom? Is there any serious and substantial issue involving your jury duty that you need to alert the court to at this time? None of the jurors have answered affirmatively. Ms. Draper, if the jury can be sworn in, the indictment's read, please.
Yes, Your Honor. Will the jury please stand and raise their right hand? Do each of you solemnly swear that you shall well and truly try the issue now pending between the Commonwealth and the defendant at the bar according to the evidence, so help you God? Thank you. You may be seated. Ladies and gentlemen of the jury, hearken to indictment number 2013-1446. The Commonwealth of Massachusetts, Essex to wit. The jurors for the Commonwealth of Massachusetts upon their oath present that Philip Chism of Danvers in said county of Essex on the 22nd day of October in the year of our Lord 2013 at Danvers in the county of Essex aforesaid did assault and beat Colleen Ritzer with intent to murder her, and by such assault and beating did kill and murder said Colleen Ritzer, against the peace of the Commonwealth aforesaid and contrary to the form of the statute in such case made and provided a true bill, signed by the District Attorney and the foreperson of the Grand Jury. Ladies and gentlemen, hearken to indictment number 2013-1447-001. The Commonwealth of Massachusetts, Essex to wit. The jurors for the Commonwealth of Massachusetts upon their oath present that Philip Chism, charged as a youthful offender of Danvers in said county of Essex on the 22nd day of October in the year of our Lord 2013 at Danvers in the county of Essex aforesaid, did have unnatural sexual intercourse with Colleen Ritzer and did compel said Colleen Ritzer to submit by force and against her will or by threat of bodily injury, and such unnatural sexual intercourse resulted in or was committed with acts resulting in serious bodily injury, or was committed during the commission or attempted commission of an offense as defined in sections 15A, 15B, 17, 19, or 26 of General Laws, Chapter 265, to wit, penetrating genital opening with a tree branch. These jurors do further present that Philip Chism is a youthful offender charged as set forth in Massachusetts General Law, Chapter 119, Section 54, said offender being between 14 and 17 years of age at the time of the offense, said offense being a felony, and said offense involved the infliction or threat of serious bodily harm against the peace of the Commonwealth aforesaid and contrary to the form of the statute in such case made and provided a true bill, signed by the District Attorney and the foreperson of the Grand Jury. Indictment 002. The Commonwealth of Massachusetts, Essex to wit. The jurors for the Commonwealth of Massachusetts upon their oath present that Philip Chism, charged as a youthful offender of Danvers in said county of Essex on the 22nd day of October in the year of our Lord 2013 at Danvers in the county of Essex aforesaid, being armed with a dangerous weapon, to wit, box cutter, did assault Colleen Ritzer with intent to rob her, and did rob or steal from said Colleen Ritzer credit card and underwear, the property of Colleen Ritzer. These jurors do further present that Philip Chism, the youthful offender, as set forth in Massachusetts General Law, Chapter 119, Section 54, said offender being between 14 and 17 years of age at the time of the offense, said offense being a felony, and said offense involved the infliction or threat of serious bodily harm against the peace of the Commonwealth aforesaid and contrary to the form of the statute in such case made and provided a true bill, signed by the District Attorney and the foreperson of the Grand Jury. And hearken to indictment number 2014-109, the Commonwealth of Massachusetts, Essex to wit. The jurors for the Commonwealth of Massachusetts upon their oath present that Philip Chism, charged as a youthful offender of Danvers in said county of Essex on the 22nd day of October in the year of our Lord 2013 at Danvers in the county of Essex aforesaid, did have natural sexual intercourse with Colleen Ritzer and did compel said Colleen Ritzer to submit by force and against her will or by threat of bodily injury, and such natural sexual intercourse resulted in or was committed with acts resulting in serious bodily injury, or was committed during the commission or attempted commission of an offense as defined in sections 15A, 15B, 17, 19, or 26 of General Laws, Chapter 265. These jurors do further present that Philip Chism is a youthful offender as set forth in Massachusetts General Law, Chapter 119, Section 54, said offender being between 14 and 17 years of age at the time of the offense, said offense being a felony, and said offense involved the infliction or threat of serious bodily harm against the peace of the Commonwealth aforesaid, and contrary to the form of the statute, in such case made and provided a true bill, signed by the district attorney and the foreperson of the grand jury. To these indictments, the defendant at the bar has heretofore pleaded that he is not guilty, and for trial has put himself upon his country, which country you are. You are now sworn to try the issue. If said defendant is guilty, you will say so. If he is not guilty, you will say so, and no more. Members of the jury, hearken to your evidence.
On October 22nd of 2013, Colleen Ritzer went to work at Danvers High School dressed in a purple sweater and black pants to match her colleagues for Buddy's Day. She carried with her her black Vera Bradley school bag and her purple lunch tote, and the knowledge that she was doing the job she'd always dreamed of, teaching math. On October 22nd of 2013, when 14-year-old Philip Chism arrived at Danvers High School, he had in his possession a blue sweatshirt with a hood, gloves, a mask, a box cutter, and a terrible purpose. A terrible purpose that would only truly be uncovered the next day in the woods next to the school by Massachusetts state troopers with the Massachusetts Crime Scene Services section as they carefully uncovered Colleen Ritzer's lifeless body. That Tuesday should have been like any other day at Danvers High School, and for much of the day it was. The 9th grade math class that Colleen taught that the defendant was in fell at the end of the day on that Tuesday. It began shortly after 1 and ended just before 2 o'clock. The defendant, who was new to the town of Danvers, having moved from Tennessee, and Colleen was on a group of teachers called the freshman team that kept an eye on that year's freshman class that were in their classes, seeing how they were adjusting to the high school, and in the case of the defendant, seeing how they were adjusting to Danvers. The defendant arrived in class, and you'll hear that different students have different memories of that last class that Colleen taught, but that overwhelmingly nothing remarkable happened in that math class. After class, there was a period where teachers could make themselves available to students who needed extra help between the end of school and when sports and other activities started. Colleen was available that day, and the defendant stayed behind. He was joined by a young woman named Autumn Ciani, who was in a different math class, but who came to Colleen's class after school. And I expect you'll find that Autumn was there less for extra math help than to spend time with her favorite teacher. But Autumn was in the classroom that afternoon and had an opportunity to observe the interactions between the defendant and Colleen Ritzer. Saw them having a conversation. Observed that Colleen was asking the defendant how Danvers was different than Tennessee, how he liked the change. Autumn sensed that the defendant was irritated with the line of questioning, that Colleen didn't notice at first, but that when she did, she moved on to a different topic. Shortly, about 2:20 in the afternoon, Sarah Giaquenta, a close friend of Colleen's and a fellow math teacher, came by the classroom. She'd had a meeting and she wanted to debrief with Colleen. And the two young women stepped into the hall, first into another teacher's empty classroom across the way, and then as they lingered in their conversation, standing just outside Colleen's classroom. While Colleen was gone, the defendant joined Autumn at the front of the classroom at the whiteboard, and they interacted the way teenagers do. He said he'd write her name for her in Japanese on the whiteboard, and he did. Eventually, Colleen returned to her classroom and let the kids know it was time to move along, that the day was over. Autumn packed her things and left, and the defendant stayed behind. As was her habit, Colleen made her way to the second-floor girls' room across the stairwell from her classroom before making the ride home to Andover. The defendant left the classroom just behind Colleen, looked up both ways, briefly re-entered the classroom, and came out with his hood over his head. As he passed across the stairwell, he was putting gloves on. He hesitated in the doorway of the bathroom as if waiting for something, and then followed Colleen in. What we know about what happened in that bathroom, ladies and gentlemen, will come to you through the testimony of the medical examiner, through the testimony of the police who recovered evidence in the woods, and from the forensic scientist who tested the evidence recovered from Colleen Ritzer's body. The defendant strangled Colleen. The defendant used the box cutter he had to cut or slice her throat. And the sperm that was present at autopsy in Colleen Ritzer's vaginal canal tells us the defendant, whose DNA profile is a match and consistent with the partial DNA profile taken from Colleen's body, raped Colleen in that bathroom with his penis. The defendant was in there with Colleen for 11 minutes. At the 11-minute mark, a young woman named Danielle Bedard briefly entered the bathroom trying to find service in the school so she could call her father for a ride home. She only made it past the doorway and a short half wall that's there when she saw a pair of naked buttocks, somewhat darker skin than her own. And she turned and walked out of the bathroom immediately with a little smile on her face, embarrassed that she'd caught someone changing. The defendant exited the bathroom almost immediately behind Danielle and made his way down the hall to the other end of the school, where he walked outside. A mother named Carolyn Quigley was there to pick up her daughter and saw the defendant doing something in the shrubs. When the defendant exited the bathroom, he was carrying what appeared to be Colleen Ritzer's pants and something white, maybe the gloves. After he was in those shrubs, he re-entered the school, and now he's no longer wearing his sweatshirt, he's not carrying anything, he's in jeans and sneakers and a t-shirt, and there's something red on one of his hands, all over one of his hands. He returned upstairs to the second floor and went into Colleen's classroom, where he stole her school bag, her purple tote, and his own backpack, and the red sweatshirt he had worn to class, the red sweatshirt without a hood. He made his way back down the hallway to the bottom of the stairs, where you will learn recycling totes, large recycling barrels with wheels, were kept by the school. He almost immediately returned back upstairs without any of the bags or clothing and headed towards the girls' room when he encountered a friend of his, Ramsey Escarcia. Ramsey wanted to know why he wasn't at soccer. Wasn't he going to come practice with him before soccer practice? And Ramsey followed behind the defendant down the hall as the defendant first asked him for help and then told him he didn't need his help. He would see him at soccer practice. And Ramsey went on his way, kicking his soccer ball, oblivious to what was unfolding in the bathroom. The defendant went back downstairs, took one of the recycling barrels, rolled it to an elevator, and brought it up to the second floor and into the girls' room. He was in there for 6 minutes. And when he exited the girls' room, he is struggling with the weight of the recycling barrel. Got back on the elevators and took them down to the first floor and pulled the barrel out of the building. At first, he went all the way around the side of the building behind the field house where the athletic fields are, and where you will learn there is a way to access the woods that are next to the school, but it's steep and it's rocky. A young woman named Emily Roach was sitting on some picnic benches there, sitting out of track practice because of an injury, and she saw the defendant trying to pull the barrel up into the woods. She thought it was someone working for the school getting rid of yard waste in the fall, and her attention wandered. The defendant eventually gave up and made his way back around the perimeter of the school, walking along the edge of the woods, and ultimately disappearing into the woods with the recycling barrel directly across the parking lot from the academic wing where Colleen's classroom was. The defendant spent the next 30 minutes in the woods, discarding evidence, doing what he wanted, and ultimately discarding Colleen. When he returns from the woods, he's dressed only in a t-shirt and jeans, no socks or sneakers, and there's now red all down the front of his jeans. He re-entered the high school, goes directly to the third floor to his locker where he gets a backpack, went to the third floor boys' room, and changed into his soccer clothes. A black shirt, black shorts, barefoot at that point, carrying his jeans and t-shirt. He returned to the woods and spent another 12 minutes or so in the woods, emerging to put on a new pair of sneakers and make his way towards the field house, towards the athletic fields, where students were more likely to be around that time of afternoon. And he ran into someone he knew, his friend Kevin Hebert. Kevin didn't attend Danvers High School, he was homeschooled, but he knew the defendant from church, and he played sports for the town of Danvers. They had been in the same youth group since the defendant moved from Tennessee, and on a few occasions the defendant had joined Kevin and his father at men's Bible study. And Kevin had a conversation with the defendant standing there on the sidewalk while Colleen's body lay in the woods. Asked if he'd gotten a text he'd sent, and the defendant said no, he'd been out of minutes. And they made plans to go to youth group that weekend, and the defendant moved on. Made his way through the locker room, through the field house, back up to the third floor of the academic wing, and eventually made his way out of Danvers High. We know he then traveled to a shopping area along Endicott Street in the town of Danvers. He went into a BJ's warehouse, sipping a sports drink, and he stole a scuba knife. He bought himself a cheeseburger and a soda at Wendy's. He went to the movie theater at the Liberty Tree Mall, and he bought himself a ticket to Gravity and watched a movie. And each of those purchases he made that late afternoon, he made with Colleen Ritzer's credit card. The first inkling anyone in law enforcement had that something had gone wrong was when the defendant's mother called the Danvers police around 6:30 that night to report him missing.
Kick off your holiday season in grand style with Boston Ballet's The Nutcracker. This classic is truly a treat for all ages. It opens Thanksgiving weekend with tickets starting at just $35. Order yours today at bostonballet.org and make memories to cherish with the ones you love.
The station when he saw someone off the road, walking in the dark where there's farmland, where the road's narrow and badly lit, and he called it into the station. Officers Neil Hovey and Joe DiBernardo left the Topsail police station in tandem, Officer Hovey arriving where the defendant was first. And he made contact with the defendant in an area where Route 1's particularly narrow, where there's a bridge that goes over the Ipswich River. The defendant wouldn't look at him, stared straight ahead. Officer Hovey asked if he had identification. He said no. Asked some other questions, where he was going, where he was coming from. Officer DiBernardo had arrived and asked about the backpack the defendant was carrying. He said it contained survival gear. Officer Hovey was concerned enough that he patted down the defendant's pockets. In one, he found a rock. In the other, he found credit cards and identification in the name of Colleen Ritzer. The name didn't mean anything to the Topsail police at that time. They asked the defendant about him, and he said something about getting them from a lady's car at a Stop and Shop. They moved the defendant across the street to an area between their cruisers where it was better lit and safer. And at some point, the defendant told them his name. And they were elated. They'd found the missing teen from Danvers. And the worst was maybe he'd taken someone's credit card. They called it into dispatch to let Danvers know, got the defendant warm in the back of the cruiser, and returned to the Topsfield police station. When they were at the station, Officer Hovey stood across from where the defendant was sitting and began to inventory his backpack. He asked the defendant, "Is there anything in here that can hurt me?" And the defendant said yes. He opened the backpack carefully, removed a white woman's wallet. He opened the wallet and saw a box cutter covered in blood. He looked up at the defendant. "Whose blood is this?" "The girl." Officer Hovey left the room to contact Danvers. Officer DiBernardo gave the defendant his Miranda rights. "Where's the girl?" "In the woods." "If we find her, can we help her?" "No." The Topsfield police couldn't have known what was unfolding at that time in Danvers, because Philip Chism wasn't the only one who didn't make it home that afternoon. When Colleen Ritzer hadn't arrived home by 3:30 or 4, her mother and sister were concerned, but thought maybe they'd just forgotten about some plans she told them about. As the night wore on, though, concern grew, and Peg Ritzer contacted Colleen's friend, Sarah Giaquenta. And Sarah and her husband offered to go to Danvers High School and see if they could find any sign of Colleen. When they arrived at the school, they saw Colleen's car, but no sign of her. They were met by another friend and teacher of Colleen's, Todd Butterworth, school personnel, and Officer Stephanie Wenneberg of the Danvers Police. And Officer Wenneberg and the two men, Todd Butterworth and Andrew Giaquenta, did a search of the school. A search that ultimately led them to the entrance to those woods across the parking lot, where between two boulders they found Colleen's black school bag. The two men then ventured further into the woods, where they began to see things covered with what appeared to be blood. And Officer Wenneberg pulled them out of the woods. The canine officer for Danvers, Justin Ellington, was working at a school nearby looking for any sign of the defendant when he heard Officer Wenneberg's radio calls about items in the woods and offered to respond with his dog. When he got there, he used Colleen's black school bag to get her scent and let the dog lead him into the woods. At the edge of the woods, the dog came upon a pair of cleats, a pair of woman's black shoes with a silver buckle. Further in the woods, a pair of sneakers, suede sneakers covered in blood. And then the dog led him out of the woods to an area just to the left of the entrance where there's an embankment next to some utility equipment and pricker bush. And Officer Ellington tied up the dog and crawled down into the pricker bush, where he found a large recycling barrel on its side. And when he flashed his light inside it, he saw blood and bloody clothes nearby. As this was unfolding, officers were responding to Danvers High School. Danvers officers, Danvers detectives, state police detectives, crime scene services people, and chemists. One of the first to arrive was Officer Steve Baldessari, the school resource officer for Danvers High School. Danvers High School was recently reopened, refurbished, with 140 surveillance cameras. And much of what I've told you about the defendant's movement in the school, you will see captured on those cameras. But that night, it was new equipment from different vendors, and the cameras weren't numbered right. And Officer Baldessari struggled to pull up the footage they needed. The system kept crashing, and it was hard to follow someone from one camera to another. But ultimately, he saw Colleen Ritzer enter the bathroom, the defendant enter the bathroom, and Colleen never come out of that bathroom. Officer Wenneberg was sent to the second floor girls' room to examine it. And she found a small amount of blood dripping down the door frame. What she couldn't know, what no one realized at that time, was that that afternoon there had been a terrible miscommunication. and the cleaning crew that are hired to clean Danvers High School had arrived and found the bathroom in the crime scene that it was. They had gone to try and alert the Danvers custodial staff, but their conversation was literally lost in translation. And the Danvers custodial staff didn't understand what they were trying to tell them and just gave them the equipment and the key necessary to hose down the bathroom, and the bathroom was cleaned. Over the course of the night, the officers in Danvers learned that the defendant had been located in Topsfield, but they still didn't know where Colleen was. Until 3 o'clock on the morning of October 23rd, Lieutenant Michael Holleran of the Massachusetts Crime Scene Services Section and 2 chemists from the crime lab were in the woods searching. They made their way down a path that leads back down towards the parking lot, and as they made their way back up, with Lieutenant Holleran flashing his flashlight, he saw a disturbance in the leaves. And he began to flash his light in that area until there was an outcry from one of the chemists. There was a toe protruding from the leaves, the toenail painted in pink polish. And Lieutenant Holleran moved to where the top of the person should be and uncovered a small amount of leaves. And even though he knew what he was seeing, he sent the chemist to get an EMT. And the EMT came into the woods and confirmed what they already knew, that 24-year-old Colleen Ritzer was gone. At that point, Lieutenant Holleran made a decision that there was nothing more they could do for Colleen, that they needed to preserve the school, preserve the woods, and take their time documenting and collecting evidence. So it was hours later, when the sun was up, that he and 2 other troopers began the painstaking process of uncovering Colleen's body and found the picture the defendant had painted for them. She lay to the side of a path on her back. There was a gaping wound to one side of her neck and cut marks to the other side of her neck. The medical examiner would ultimately determine she had been cut and stabbed with that box cutter at least 16 times. Major arteries in her neck were cut, and the defendant cut so deep he nicked a vertebra. The defendant had taken that purple sweater and the white tank she wore underneath and pulled them up. He had pulled her bra down, exposing her breasts. She was naked from the waist down, her pants discarded nearby. Her underwear he took. They were in his backpack when he was stopped in Topsfield. And before he left her and buried her, the defendant had spread her legs open and forced a tree branch into her vagina, staining the tip with her blood. Ladies and gentlemen, you're all aware of the painstaking process we went through to select you, and it required enormous patience on your part. And that's all I ask of you now: your patience, your attention, your common sense, and your life experience. There will be a lot of evidence in this case, and some of it will be difficult. But when you have heard all of the evidence in this case, I will come back to you and I will submit to you at that time that the Commonwealth has proven beyond any reasonable doubt that the defendant is guilty for the intentional and knowing murder of Colleen Ritzer with extreme atrocity and cruelty, with deliberate premeditation, in the furtherance of a life felony, that the defendant is guilty as a youthful offender for raping Colleen in that bathroom, for robbing her of her credit cards and underwear, and for raping her in the woods with the tree branch. Thank you.
Do you wish to make an opening at this time?
I do, but first I'd ask to approach.